The air in the Supreme Court chamber was heavy with expectation, thick, almost sacred. Marble columns rose toward vaulted ceilings, capturing the whispers of history and power. Portraits of past justices stared down from the walls, their painted eyes witnessing yet another clash in the never-ending war over American justice. And then it happened, a sound no one expected. Laughter, not polite laughter, not nervous laughter, but the deep, rolling, unmistakable sound of dismissal. Justice Clarence Thomas, 76 years old, draped in black robes, his face carved by 3 decades of unyielding conservative jurisprudence, was laughing at the woman standing before him. Representative Jasmine Crockett stood at the podium, her posture straight, her burgundy blazer sharp against the muted tones of the courtroom. Her natural hair was styled in elegant locks, framing a face that had learned long ago not to flinch. She had just delivered the opening salvo of her argument in a landmark voting rights case, one that could determine the fate of democracy for millions of Black and Latino Americans. And Justice Thomas had laughed. It wasn't a chuckle of surprise. It wasn't even amusement. It was condescension. The kind of laugh that says, "You don't belong here." The kind of laugh that echoes through generations of courtrooms where women, especially Black women, were told their voices didn't matter. But what Justice Clarence Thomas didn't know, what no one in that chamber knew, was that Jasmine Crockett had been waiting her entire career for this exact moment. And what she was about to say next would not just stun the courtroom, it would shatter it. To understand what happened in that courtroom, you need to understand who these two people really are. Clarence Thomas is not just any Supreme Court justice. He is a monument to conservative legal philosophy. Appointed in 1991 by President George H.W. Bush, Thomas barely survived one of the most explosive confirmation battles in American history. Allegations from Anita Hill nearly derailed him, but he made it through, and for over 30 years he has sat on the highest court in the land, shaping American law with an iron fist wrapped in originalist theory. Thomas believes the Constitution should be read exactly as it was written in 1787. No evolution, no modern interpretation, no concessions to a society that has changed beyond recognition. He is famous, or infamous, for rarely speaking during oral arguments, sometimes going years without asking a single question. When he does speak, his words are surgical, devastating, and designed to expose what he sees as the intellectual weakness of progressive legal arguments. To his admirers, he is a hero. A Black man who rose from poverty in rural Georgia, who refuses to be defined by his race, who stands firm on principle no matter the cost. To his critics, especially in the Black community, he is something far darker. A man who climbed the ladder of civil rights protections, then pulled it up behind him. A justice who benefited from affirmative action but now works to dismantle it. A man whose wife, Ginny Thomas, actively campaigned to overturn the 2020 election, raising questions about his impartiality. Clarence Thomas is untouchable, unshakable, unmovable. At least that's what everyone thought. Now meet Jasmine Crockett. At 43, she's young enough to be Justice Thomas's daughter, but she carries herself like someone who has earned every inch of space she occupies. Born and raised in St. Louis, Missouri, Crockett didn't grow up in wealth or privilege. Her mother worked as a supervisor at a car rental company. Her father worked for the city. She put herself through college, then law school at the University of Houston, graduating with honors and passing the bar on her first attempt. For nearly 2 decades, she worked as a public defender and civil rights attorney in Texas, defending people who couldn't afford high-priced lawyers, taking on cases of police brutality and voting rights violations that more prestigious firms wouldn't touch. In 2020, she was elected to the Texas House of Representatives. And when Texas Republicans pushed one of the most restrictive voting laws in the nation, Crockett didn't just object. She fled the state with other Democratic legislators to deny them a quorum, making national headlines. In 2022, she ran for Congress, and she won. In Washington, Jasmine Crockett became known for 2 things: her devastating cross-examinations, and her refusal to back down from a fight. She went viral multiple times, once for eviscerating a Republican witness on voting rights, another time for her fiery exchange with Marjorie Taylor Greene that produced the instant classic line, "Do you know what we're here for?" But Crockett isn't just a social media sensation. She's a serious lawyer with a deep understanding of constitutional law. She served on the House Judiciary Committee. She's argued before federal courts. She knows how to build a case, brick by brick, until the entire structure collapses on her opponent. And now she was standing in the Supreme Court, facing the most powerful conservative justice in America. This wasn't just a legal argument. This was a reckoning. The case that brought them face-to-face was Shelby County versus Texas Congressional District Coalition, a challenge to new redistricting maps in Texas that civil rights groups argued systematically diluted Black and Latino voting power. After the Supreme Court's devastating 2013 decision in Shelby County versus Holder, which gutted key provisions of the Voting Rights Act, states with histories of racial discrimination no longer needed federal approval before changing their voting laws. Texas wasted no time. They immediately redrew district maps, cracking and packing communities of color to ensure they could never elect their candidates of choice. Crockett, as a member of Congress representing one of those affected districts, was granted rare permission to present oral arguments as amicus curiae, a friend of the court. This almost never happens. Members of Congress don't usually argue before the Supreme Court, but Crockett's background as a civil rights attorney and her direct representation of affected voters gave her standing. For the conservative majority, this case was an opportunity to finish what they started, to deliver the final blow to federal voting rights protections. For Jasmine Crockett, it was a chance to expose the hypocrisy at the heart of conservative jurisprudence. And she came prepared. Crockett began her argument the traditional way, respectful, measured, deferential. "Mr. Chief Justice, and may it please the court," she said, her voice steady and clear. "I appear today on behalf of the hundreds of thousands of voters in Texas's 30th Congressional District who have seen their political power systematically diluted through racially discriminatory redistricting practices." She laid out her case methodically. The new Texas maps split historically Black neighborhoods in Dallas, combining them with rural white areas to ensure Black voters could never win. The data was overwhelming. Expert witnesses had proven these maps could not have been drawn without race being the predominant factor. "The evidence shows," Crockett continued, "that Texas legislators specifically targeted districts with growing Black and brown populations, using sophisticated software to identify racial demographics down to the block level, and then drew lines that—" That's when Justice Thomas interrupted. "Counsel," his deep voice rumbled across the courtroom like distant thunder, "are you seriously suggesting that a state legislature cannot consider population shifts when drawing district lines? That's literally their job." Crockett paused, but only for a heartbeat. "Justice Thomas, I'm not suggesting that at all. What I'm saying is that when a state has a documented history of racial discrimination in voting, a history from 60 years ago?" Thomas cut her off again, leaning forward. "How long must a state be punished for sins of the past? Should Texas be treated as a suspect entity forever?" Chuckles rippled through the conservative side of the bench. Justice Thomas sat back. And then it happened. The laugh. Not a full belly laugh, but a dismissive chuckle accompanied by a slow shake of his head. The kind that says, "This argument is absurd. You're wasting our time." The message was crystal clear. Your position is weak, your argument is tired, and you don't belong here. The other conservative justices smelled blood. Justice Alito jumped in. "Counsel, you keep referring to dilution of minority voting power, but doesn't your theory essentially require that minorities get to win elections? That's not what the Constitution guarantees." Justice Kavanaugh piled on. "And isn't it true that Black voter turnout has actually increased in Texas since these maps were drawn? Doesn't that undermine your claim of suppression?" Justice Amy Coney Barrett added, I'm troubled by your reliance on statistical disparities. Correlation isn't causation, counsel." The questions came rapid fire, barely giving Crockett time to respond. This is a classic Supreme Court tactic: overwhelm the advocate, throw them off balance, expose weaknesses. In the gallery, civil rights advocates shifted uncomfortably. This was going badly. Justice Thomas watched with satisfaction, occasionally nodding at his colleagues' questions. He'd seen this movie before. Young, passionate advocates who think they can change the world with soaring rhetoric, only to crumble when faced with the hard realities of constitutional law. Thomas decided to deliver the knockout blow. "Counsel," he said, his voice dripping with condescension, "let me ask you something fundamental. You've been practicing law for what, 15, 20 years?" 18 years, Your Honor," Crockett replied evenly. 18 years. And in those 18 years, have you ever stopped to consider that perhaps, just perhaps, the founders did not intend for the federal government to micromanage every state election law? That maybe the 10th Amendment means something? He paused, letting the question hang. Or do you believe the Constitution is just a piece of paper we can rewrite whenever we find the current version inconvenient? Laughter rippled through parts of the courtroom. It was a devastating rhetorical blow, essentially accusing Crockett of not respecting the Constitution itself. Crockett stood at the podium, silent. This was the critical moment. Most lawyers would get defensive. They'd backtrack, offer a meek response about respecting precedent while trying to salvage their position. But Jasmine Crockett was not most lawyers. What Justice Thomas didn't know, what nobody in that courtroom knew, was that Jasmine Crockett had spent the last 3 months preparing not just for this case, but specifically for this moment with Justice Thomas. She had studied every opinion Thomas had written in his 30-plus years on the court. She had read his autobiography cover to cover. She had watched recordings of his speeches. She had analyzed his questioning patterns, his rhetorical tactics, his favorite arguments. And she had discovered something crucial, a contradiction at the heart of Justice Thomas's judicial philosophy that he had managed to avoid confronting for 3 decades. In her hotel room the night before, Crockett had reviewed her notes one final time. Her team had found a series of Thomas's own opinions that, when placed side by side, revealed a stunning double standard. They had prepared the receipts. But she needed Thomas to walk into the trap first. She needed him to commit to his position clearly, unequivocally in front of the entire court and the national media. And with his dismissive question about the Constitution being just a piece of paper, he had done exactly that. Before Crockett could respond, Chief Justice Roberts held up his hand. "Justice Thomas, let's allow counsel to answer the previous questions before we move to new ones," Roberts said diplomatically. He could sense the tension rising, but Justice Thomas waved him off. "My question directly follows from her argument, Mr. Chief Justice. I think counsel can handle it." That last phrase, "I think counsel can handle it," was delivered with just enough skepticism to be insulting. The room fell completely silent. Every eye was on Jasmine Crockett. She took a slow, deep breath, and then she began to speak. "Justice Thomas," Crockett said, her voice suddenly sharper, more focused, "I'm so glad you brought up the 10th Amendment and what the founders intended, because that's exactly what I want to discuss." Thomas raised an eyebrow, surprised by her confident tone. "You asked if I've ever considered that the founders didn't intend for the federal government to micromanage state elections. The answer is yes, I've considered it extensively." She paused. "Have you ever considered that the founders also didn't intend for black people to vote at all?" A gasp rippled through the courtroom. You don't throw that kind of direct challenge at a Supreme Court justice, especially not Justice Clarence Thomas. But Crockett wasn't done. In fact, when the Constitution was written in 1787, the document you just asked me about, the founders counted black people as 3/5 of a person for purposes of representation, but gave us 0/5 of voting power. We weren't citizens. We were property. Justice Thomas's face darkened. Counsel, I'm well aware of the history. Then you're aware that it took a civil war and 3 constitutional amendments, the 13th, 14th, and 15th, to even begin to address that original sin. Amendments that fundamentally rewrote the federal-state balance of power, specifically to empower the federal government to protect the rights of Black Americans against state suppression. Crockett pulled out a document from her folder. In fact, let me read you the exact text of the 15th Amendment, Section 2. The Congress shall have power to enforce this article by appropriate legislation. Not the states, Justice Thomas. Congress, the federal government. That's in the Constitution, too. The courtroom was riveted. Justice Thomas leaned forward, clearly irritated. Counsel, nobody disputes that the Reconstruction Amendments exist, but they don't give Congress unlimited power to— You're absolutely right, Justice Thomas, Crockett interrupted smoothly. They don't give unlimited power, which brings me to my next point. She pulled out another document marked with colored tabs. In your opinion, in Shelby County v. Holder in 2013, you wrote a concurrence arguing that Section 5 of the Voting Rights Act was unconstitutional because it treated states unequally, correct? Thomas nodded slowly, unsure where this was going. That's correct. Equal sovereignty among the states is a fundamental principle. Equal sovereignty. I like that phrase, Crockett said. So, in that case, you argued that the federal government couldn't treat southern states differently than northern states, even though southern states had documented histories of racial discrimination in voting. The principle of state equality was so important that it outweighed the federal government's power to protect voting rights under the 15th Amendment. Is that a fair characterization? Oversimplified, but essentially yes, Thomas replied. Great. Now let me ask you about another case. Crockett flipped to a different tab in her binder. In Trump v. Anderson this year, the question was whether states had the power to remove Donald Trump from the ballot under Section 3 of the 14th Amendment, the Insurrection Clause. You joined a unanimous opinion saying that states cannot make their own determinations about federal candidates' eligibility, that only Congress can enforce Section 3. Correct? That was about creating uniform rules for federal elections, Thomas said, his tone becoming defensive. We can't have a patchwork system where candidates are on the ballot in some states and not others. Crockett smiled. Not a smirk, but a genuine smile of someone who knew they had just won. Justice Thomas, help me understand your judicial philosophy. She held up 2 documents, one in each hand. When states want to restrict voting rights, dilute minority votes, purge voter rolls, and make it harder for Black and brown people to cast ballots, you say the federal government can't interfere because of state sovereignty in the 10th Amendment. Equal sovereignty among states is sacred. She paused, letting that sink in. But when states want to exclude a candidate from the ballot, a candidate who happens to be your preferred candidate, suddenly state sovereignty doesn't matter anymore. Suddenly, we need federal uniformity. Suddenly, Congress's power to enforce constitutional amendments is paramount. The courtroom erupted in whispers. Justice Sotomayor's eyes widened. Justice Kagan covered her mouth. Crockett pressed forward, her voice rising with controlled passion. So, which is it, Justice Thomas? Is state sovereignty sacred, or isn't it? Does Congress have the power to enforce constitutional amendments, or doesn't it? Or does your interpretation of federalism simply depend on whether the outcome protects your political preferences? Justice Thomas's face flushed red. Counsel, you are out of line. Am I? Crockett shot back. Because from where I'm standing, it looks like you have 2 different constitutions. One that protects state power when states want to suppress minority votes, and another one that requires federal power when you want to protect a particular presidential candidate. The gallery exploded. People were whispering loudly. Some were openly talking. Civil rights advocates in the audience were grinning, barely containing their excitement. Chief Justice Roberts banged his gavel. Counsel, I must ask you to moderate your tone and show proper respect to the court. Crockett nodded. My apologies, Mr. Chief Justice. I have nothing but respect for this institution. That's precisely why I'm pointing out when its jurisprudence appears inconsistent. She turned back to Justice Thomas, who was gripping the arms of his chair, his knuckles white. Justice Thomas, you wrote in your Shelby County concurrence that the Voting Rights Act was an affront to state dignity. You said states have grown and changed, that we must have faith in their democratic processes. She pulled out a statistical chart. But Texas has passed more restrictive voting laws in the last 3 years than in the previous 30. They've closed polling places in minority neighborhoods, limited voting hours, banned mobile voting, criminalized helping voters with their ballots. She held up the chart. In the 2022 election, voters in predominantly black precincts in Dallas County waited an average of 73 minutes to vote. Voters in predominantly white precincts waited an average of 11 minutes. Her voice dropped to just above a whisper, but clear enough for everyone to hear. That's not democracy, Justice Thomas. That's suppression. That's exactly what the Voting Rights Act was designed to prevent. Justice Thomas finally found his voice. Counsel, you are making political arguments, not legal ones. Your personal feelings about voting policy are not relevant to constitutional interpretation. You're absolutely right, Crockett said. Personal feelings are irrelevant, which is why I'm asking you to apply the law consistently. She held up her 2 documents again. In your left hand, I have your Shelby County opinion saying Congress exceeded its authority under the 15th Amendment. In your right hand, I have your Trump v. Anderson opinion saying only Congress can enforce Section 3 of the 14th Amendment. She brought her hands together. These can't both be right, Justice Thomas. Either Congress has broad power to enforce constitutional amendments, including protecting voting rights, or states have sovereignty to interpret those amendments themselves, including determining candidate eligibility. The trap was complete. Crockett had used Thomas's own words, his own jurisprudence, to expose the contradiction at the heart of his philosophy. Justice Alito tried to help. Counsel, you're comparing apples and oranges. Both amendments have identical enforcement clauses, Crockett said, not even looking at Alito. Her eyes remained locked on Justice Thomas. Section 2 of the 15th Amendment and Section 5 of the 14th Amendment use virtually the same language. Congress shall have power to enforce this article by appropriate legislation. She leaned forward slightly. The only difference, Justice Thomas, is that one protects my right to vote, and the other protected Donald Trump's right to run for office. She paused. And in your jurisprudence, only the latter deserves full federal enforcement. The courtroom exploded. People in the gallery openly applauded, a violation of Supreme Court protocol. Marshals moved toward them to restore order, but there were too many people clapping. Order! Order! Chief Justice Roberts shouted, banging his gavel repeatedly. Justice Thomas sat back in his chair, his face a mask of barely contained fury. He had been a Supreme Court justice for over 30 years, and nobody had ever confronted him like this in his own courtroom. Within minutes of the session ending, clips of the exchange began circulating online. Sir Crockett v. Thomas rocketed to the #1 trending topic in the United States within 30 minutes. Jasmine Crockett just ended Clarence Thomas. 2.3 million views in the first hour. You have 2 different constitutions. The clip went viral across every platform. Legal Twitter exploded. Law professors from Harvard, Yale, Stanford, and Georgetown weighed in. From a purely legal standpoint, Crockett identified a genuine tension in Justice Thomas's federalism jurisprudence. This will be studied in con law classes for years. Professor Leah Littman, University of Michigan Law School. Even some conservative legal scholars had to acknowledge the quality of her argument. Crockett raised a fair point about the tension between Shelby County and Trump versus Anderson. Conservatives should have a better answer to this. Professor Josh Blackman, South Texas College of Law. CNN, MSNBC, Fox News, every major network covered it as their lead story. Back in Congress, Jasmine Crockett became an instant hero to progressives. Representative Alexandria Ocasio-Cortez tweeted, "This is what it looks like to fight for your constituents. Jasmine for us didn't back down. We need more of this, not less." But Republicans were furious. House Speaker Mike Johnson. Representative Crockett's disrespectful treatment of Justice Thomas was appalling. She owes him and the court an apology. Senator Ted Cruz. Disgraceful. She's not a serious lawyer. She's an activist in a suit. This backfired spectacularly when Crockett responded with a simple tweet. "I graduated from law school with honors, passed the bar on my first try, practiced law for 18 years, and was elected by the people." What part of that is DEI? The tweet got 4.7 million views. The Supreme Court would not issue its decision for months. Most observers still expected a conservative victory. But the damage was done, not to the outcome of the case perhaps, but to the court's credibility and to Justice Thomas's reputation. Law schools immediately began incorporating the Crockett-Thomas exchange into their curricula. This will be shown in constitutional law classes for decades, predicted Harvard Law professor Lawrence Tribe. It's a master class in oral advocacy, but also in exposing ideological contradictions in judicial reasoning. For Jasmine Crockett personally, the consequences were mixed. She became a national figure overnight. Her fundraising exploded. Over $2 million in small-dollar donations in 1 week. But she also became a target. Conservative groups launched attack ads. She received death threats serious enough to require enhanced security. "I knew this would happen," Crockett said in an interview a week later. "When you stand up to power, especially as a black woman, they come for you. But I'd do it again in a heartbeat. Because this isn't about me. It's about the millions of voters who are having their voices silenced." When asked if she regretted her confrontational approach, Crockett was unequivocal. "Not for 1 second. People keep asking me if I was too aggressive, if I was disrespectful. But let me ask you this. Is it disrespectful to point out when a Supreme Court justice applies one standard to protect voting rights and a different standard to protect a presidential candidate? Because I call that doing my job." 6 weeks after the oral arguments, Justice Thomas gave a rare public speech at a Federalist Society event. "The role of a judge," Thomas said, "is to apply the law without fear or favor, not to be popular, not to be liked, and certainly not to bend to political pressure or theatrical performances in the courtroom." The audience of conservative lawyers applauded. But even in this friendly setting, Thomas seemed defensive, spending nearly 10 minutes defending his approach to federalism. He never actually addressed the specific contradiction Crockett had identified. He never explained why state sovereignty was paramount in voting rights cases but not in candidate qualification cases. He simply asserted his neutrality and moved on. Jasmine Crockett, for her part, had already moved on to her next fight. She introduced the Voting Rights Advancement Act in Congress, legislation to restore the provisions gutted by Shelby County. She gave fiery speeches on the House floor. She organized voter registration drives in Texas. And whenever she was asked about that day in the Supreme Court, she smiled. That same confident smile she'd given Justice Thomas right before she destroyed his argument. "I went into that courtroom knowing I might not win the case," she said, "but I also knew I had truth on my side. And in the long run, truth always wins." Whether that optimistic assessment would prove correct remained to be seen. The Supreme Court's conservative majority remained intact. Voting rights continued to be under assault. The battle Jasmine Crockett fought that day was just one battle in a much larger war. But for one shining moment, she had done what millions of Americans had dreamed of doing. She had stood before power, refused to be intimidated, and spoken truth without fear. And in doing so, she had shown that even in the face of overwhelming institutional authority, one person with courage and conviction can still make a difference. If this story moved you, if you believe in the fight for voting rights, if you think it's important to hold powerful institutions accountable, then hit that subscribe button and share this video, because truth deserves witnesses, and the fight continues.